In this week's module, we will cover three distinct topics, and though these topics are somewhat unconnected, they all share a common theme, which is the limits the UCC places on the freedom of contract. Recall, the freedom of contract is a bedrock of contract law in our system of personal liberty. The freedom of contract is the freedom of individuals to determine for themselves and without government interference what legal rights and obligations they want to create for themselves. It is the power of individuals to make their own system of private law through the creation of contracts with other parties, private law that is enforceable through the powers of the state, through the state's judicial system. So the freedom of contract is the freedom of individuals and not the state to choose which contracts to be bound to. Stated differently, the government, the courts, the state more generally, do not get to choose which contracts to enforce. The state's role is merely to enforce the contracts that private individuals make for themselves. The UCC curtails the freedom of contract in three areas, which will serve as our roadmap for this week's module. The ability of contract parties to override the statutory gap fillers of the UCC, the ability of contract parties to disclaim express or implied warranties, and the ability of contract parties to modify the default remedies provided by the UCC available in the event of a breach. In each instance, it is worth asking, why does a state, through its law and specifically here through the UCC, limit the freedom of parties, limit what kinds of contracts that parties may agree to? In each instance, the UCC's limits on the freedom of contract reflect a degree of paternalism, implying that the state, through its law, must limit what parties can agree to protect contract parties from themselves, because private individuals may not know what's best for themselves. But there's a second, more benign explanation for these limitations on the freedom of contract, which is the same one that we noted in our discussion of unconscionability, namely, that the freedom of contract is not the only policy at stake here. The freedom of contract is an important policy, but it is one that must be balanced against another competing policy, the desire to ensure justice, to ensure equity, to ensure just or fair results by preventing the judicial enforcement of agreements where the terms are manifestly unjust or unfair. This policy recognizes the reality that in some transactions, the parties may have unequal sophistication or bargaining power. In particular, where the seller is a business and the buyer is a consumer, think, for example, an unsophisticated consumer buying a new phone from a certain fruit-branded phone manufacturer. In that kind of situation, often the contract between the parties will be formed on the basis of a contract of adhesion, drafted by the business and its sophisticated attorneys and presented to the consumer on a take-it-or-leave-it basis without an opportunity to negotiate the terms. In those circumstances, we all know from our own experience the consumer will not bother to read or understand the terms that she is being asked to agree to. Thus, where one party, the more sophisticated party, has the power to dictate terms of the contract, there is a risk, the risk of overreach, the risk that the more sophisticated party will draft terms that favor itself to a degree that is simply unfair or unjust. So, as with the doctrine of unconscionability, we can try to justify the limits on the freedom of contract that we will cover in this week's module as necessary to discourage this kind of overreach. Discourage it by providing that not all contract terms are enforceable by the state, especially when the enforcement of the contract's terms would have manifestly unjust consequences. We will start this examination by looking first at the limits that the UCC places on the ability of contract parties to override the gap filler provisions of the UCC.